3, for example, have come in with
Can
modifications.
Parliament not have amended the Constitution exercising the 368 power to abrogate 370?
No.
Which means, therefore, that...
And under one saying that all the provisions of the Constitution apply, and list them all of them and say all of them apply.
The problem there is, if you say all of them will apply, it applies to what? The concurrent list. All right, let's not talk of 2023, Malad. In 1950, what was the position? This was the position.
It could be done. Parliament.
No,
how can we say that Parliament could not have exercised its plenary amending power
This is not basic.
to abrogate Article 370?
This is not basic.
Sibal, according to you, neither the Assembly can do it,
Yes.
nor the Parliament can do it.
Yes.
What you are saying is, while other provisions of the Constitution may be capable of amendment through a process envisaged for amendment,
Yes.
other than, of course, if it is hit by basic structure,
Correct.
this is one provision which can never be amended.
And let it put it differently. But let me put it, under what power will this take place? Let's assume Malaj can do it. If my lords
I'm just
put the
thinking
question to
aloud.
me,
To have a
under which provision of the Constitution can they do it?
Having a permanency, the whole concept is that Constitution is also a live document. At some stage, can we say there is no mechanism whatsoever for ever changing it, even if everybody wants to change it, and it doesn't affect the basic structure? Then to say that if suppose all of Kashmir wants it, hypothetically,
Then a political act can be, but there can be a political act.
And those negotiations.
Clause 1 is the answer to this. 370 clause 1, bit by bit, modifications, exceptions, applications have come. Now, and one important thing your lordship may note is it's completely irreversible. Because it's completely irreversible, all those parts which have now been brought in, they cannot now reverse. So part 3, for example, have come in with
Can
modifications.
Parliament not have amended the Constitution exercising the 368 power to abrogate 370?
No.
Which means, therefore, that there is a provision of the Constitution, apropos what fell from Brother Justice Call, that according to your submission, there is a provision of the Constitution which lies even beyond the amending power of Parliament.
That's right.
Your lordship may note
So we are creating then a new category apart from basic structure.
No, not
That 370 belongs to that.
It is inherent and it's integrated into 370 itself. It's not a new category. It's a category that exists.
370 clause 3 only provides that if you want to abrogate, there is a mechanism for abrogation, which is why it's temporary. Now, if 370 clause 3 goes and is not brought into service, 370 clause 1 can now be used continuing with the legislative assembly, with the government of Kashmir, giving its consent, and the entirety of the Constitution can be made applicable to Kashmir still under 370 clause 1. It can still be done. So the answer is not that it can't be done.
I'm sorry.
Let's assume
Is it-
what your argument on clause 3,
Is
which has
allowed.
been argued that clause 3 is today etched in stone, is now, it cannot be.
want to put
Yes.
is that 371, according to 370 sub-clause 1, itself envisages bringing in different provisions.
Correct.
Tomorrow, through that process, it is said that each and every provision of the Constitution applies to the state of JM.
Yes.
Then what remains of 370?
Nothing.
Then the only.
To say that you can,
It can
in
be
a
taken.
sense, make completely 370 infructuous, yet it is sacrosanct where it can never be removed.
Let me just explain, Manoj. Clauses 1 and 2 and 3 have to be read together. 2 is transitory. 3 provided for abrogation to be temporary. So if you have a constituent assembly and they are giving their recommendation, then the abrogation was immediately possible. It's a shortcut and 370 comes to an end. The long way around is through 370 clause 1 with applying provision of part
So
1.
I'm saying therefore said that
Yes.
371, according to you,
Yes,
can mean, orders have been issued from time to time.
yes.
That it can say that each and every provision of the Constitution.
It can, of course.
Correct. Once we come to that,
Yes.
I'm just thinking aloud. What remains in 370 after that? Which means
So
you are saying the shell of 370 should remain, but the substratum can
we are
be.
saying that assimilation needs to follow the correct procedure. The 370 clause 1 procedure is still available, was what we are arguing.
I don't know what
It's
he's arguing, but it's certainly not what I'm.
It's what we are saying.
Yes, sir.
That-
Yes.
That may be his
The
interpretation.
expression.
I think, let Mr. Sibal come, because, otherwise that will, I think, Mr. Shankar, what will happen is, we are following a certain line and a link and a syntax, so. I mean, I think, we might be broken up in the nuance, of.
Because, respect Mr. Sibal, he knows the law. We also will therefore didn't jump and answer the questions.
I don't think.
See, the nuances are so many as something Mr. Sibal is arguing, something which you propound to do so. Mr.
Yes, he
Dwivedi
can.
said, no, this is not what I am saying something different. So we'll have to see where the call, right?
You can't
I
say
understand, so
something
your
different, there's no
argument I've
issue at all.
understood at your own turn. He says that you can keep the shell, but the process is 2, 370 and
There
1.
is another interpretation.
Well, the problem is that if there's a constitutional process to do it, it can be done. If there is no constitutional process to do it, then it has to be a political act.
He's
So why
saying there
not?
is a constitutional process by which it can be done under 371.
No, you can't do away with
Okay, I-
370 sub clause 3.
No, suppose, after all, orders have been issued from time to time, bringing different provisions of the constitution in
Right,
force.
right.
Can you not say that another order be issued that it can under one saying that all the provisions of the constitution apply and list them, all of them, and say all of them apply?
The problem there is if you say all of them will apply, it applies to what? The concurrent list and the instrument of accession.
This is
That's correct.
insofar as the clause D is concerned, the requirement is more stringent and concurrence is required.
That's list 3, Mother. That's concurrent list. Residuary power is always with the state. That's the problem. That can't be done by any process. Even under 370 sub-article 1. That's the problem. But I see the point that my lord is making, that look, once the Constituent Assembly is over, then of course there's a status quo, it can't be changed. This is what my lord is putting to me. Yes, there is, but then we have to find a constitutional procedure through which it can be done.
Not amount to equating it with the principle of basic structure itself, that it can never be done. Like you cannot, and that also through a judicial pronouncement,
No,
the
but
philosophy of
Let's
basic structure.
all right, let's not talk of 2023, Madhaj. In 1950, what was the position? This was the position. That it can't be done.
No, but prior to the basic structure doctrine itself, it could be done. Parliament,
no,
how can
this-
we say that Parliament could not have exercised its plenary amending power
This is not basic.
to abrogate Article 370?
This is not basic structure, Madhaj. This is a compact between one sovereign and another engrafted in our constitution. It's a constitutional compact.
Then what happened?
Unlike other states where Junagadh, Malaj, he didn't agree, as a political act, you took over Junagadh. He ran away, the Maharaja ran away,
But
Malaj.
that, Mr. Sibal, I think we are treading on thin ice, because the moment we say that this was just a recognition, this was a recognition of a compact between one sovereign state and another which forms a part of our constitution, then such a sovereign compact is capable of being overridden
That's all right, Malaj. So then we could.
by the sovereign of the succeeding state.
That debate is a separate debate which doesn't arise in this case because there's a procedure that they have followed. That debate doesn't arise here, Malaj. We're not talking of that at the moment. That's not an issue. We're talking about a procedure in terms of 370, which they followed, consistent with the interpretation of 370. Having taken that position that we need the consent of the Constituent Assembly.
Is this the Constituent Assembly according to you?
Yes,
Yes.
that's right. That's the procedure.
That we've
We're
appreciated
only
that
on that.
submission. Yes, of course, we have appreciated that
We are
submission.
limited only on that.
That the
Large-
process, in other words, your contention is that the process which the government of India followed assumes that the proviso to clause 3 apply,
Yeah,
that this change has to be brought in through a Constituent Assembly.
correct.
But this was evidently not the Constituent Assembly, because A, it was a legislative assembly that you have invoked, and two, even that legislative assembly was dissolved and ultimately Parliament was exercising that power under 356.
Not